Okay. Can we see those
Yeah,
slides?
we can see your slides. Yep.
Brilliant. Well, look, good afternoon, everyone. Absolutely delighted that you guys have taken the time to join us on this webinar today to look at the benefits of becoming an independent consultant solicitor. My name is Darren Gibson. I'm the managing partner of Gibson and Associates LLP. We're a nationwide legal practice. We have a 60-strong team, and we practice mainly in the areas of property, litigation, and immigration. We have a couple of subsets within our litigation of medical negligence and PI, together with data protection. And we like to think that we help clients solve lots of problems. We like to think that we make a very positive impact in the communities that we serve. We like to think that we offer career progression for any of the people that work in our business. And we like to think that we do some very good business along the way. I'm delighted as well that I've been joined today by Neil Butler, our first independent consultant solicitor, who we'll be talking to in a few moments, and also Roxy George, our marketing manager. And thanks to Roxy and Justin for setting up today's webinar. Just a little bit of background on the independent consultant solicitor program. This is something we looked at around 2 years ago. We felt that there was room for an alternative model for the delivery of legal services in the Irish legal market that would effectively take advantage of the economies of scale that are available, ultimately with a view to benefiting the experience for the legal professionals providing the service, and ultimately the consumer of those legal services. We feel that the independent consultant solicitor model goes a very, very long way to achieving that. At the moment, all you guys on the call will appreciate that particularly in the Republic of Ireland and indeed Northern Ireland at the moment, there's a very polarized method of delivering legal services. You've got the large corporate practices on one end, and then you've got the smaller 1, 2, and 3-man band type practices on the other end, with very little actually in the middle. I think the Law Society did some survey in the recent past, did a very good report suggesting that in excess of 70% of the legal practices in the Republic of Ireland have less than 2 practicing solicitors. So for us, we think that creates a very interesting prospect whereby with some collaboration and not much of a reduction in one's sovereignty, there's great savings to be made. I mean, if you think about it, we've got 70% of, in excess of 70% of the legal firms in Ireland paying all of the exact same costs, all of the same overheads, totally unnecessarily in our view. And we think that there's a great saving to be made within that will ultimately benefit the stakeholders, including and most importantly, the clients. This type of a model suits a whole range of people. It's not just sole practitioners whom it would benefit immensely. It's partners in small or legal practices, and indeed associates who want to get a greater slice of the cake sooner, rather than maybe spending a few years waiting on an equity position or an enhanced salary position. The option is very much open to them to take that pretty much straight away. So the benefits of the independent consultant solicitor model is that effectively you as practitioners plug into what is an already very established platform in our business: good case management, good financial management, good risk and compliance, great marketing end of our business, together with the shared knowledge base that exists with the 60-strong team that we have and the ever-expanding independent consultant solicitor team. But look, rather than take my word for it, I think that we will defer to Neil Butler. Neil and I met about 2 years ago. We discussed the independent consultant solicitor model. We both shared a vision for it, and thankfully Neil was the first guy to join that model, and he now leads out that end of our business. So, look, Neil, perhaps for the benefit of all of the participants on the webinar, maybe you could start with maybe sharing a little bit about your background, and then we can look at why you joined the independent consultant solicitor model.
Sure, delighted, Darren, and good afternoon to everybody from Tipperary. And again, just that small microcosm, it's flexible. I'm working from home, and it doesn't inhibit me. Clients have still got the same point of contact, and I would say probably a better range of professional capacity. But I'll explain that in a sec. Some of you from TIP would know, and maybe further afield, I ran my own business for about 27 years. Typical small rural practice. And as I said before, I'd become nothing more than an endpoint for every new risk and compliance burden, to say nothing of data management for insurance companies and arms of the state. So the true joy, I suppose, of serving clients at vulnerable times in their lives had ebbed away or been taken away by the pure time demands of compliance and the fear of making a mistake. I'm that bit older now as well, so I suppose maybe I'm feeling a bit more mortal, but there's no getting away from the fact that young or old, we have a huge burden of risk management and compliance. And working as a solo seems to me to be almost a criminal activity in the eyes of the regulators and the insurers, because we're penalized at every turn. So for me, I needed to look at something to give me more headspace and to give me capacity to go back to the basic tenets of service, of professional standards, delivered in an empathetic way. And when I saw this program and explored it, it became clear it offered the opportunity. Now, I have to say, and I'll advert to it again, Darren is a big believer and he articulates it so very well in terms of cultural alignment. And it's important for me to meet people that want to examine this, but it was important for me to meet Darren and his team, Gary in Ops and Debbie in HR and the other people, the heads of department, because that is as much part of the offering, I think. Would that be a fair comment, Darren?
Yeah, I mean, spot on, Neil. I mean, the whole approach here is getting groups of people to work effectively together with a view to achieving a common aim, a common mission. And ultimately, what we're about as legal professionals is solving people's problems and getting a result for clients that makes life that little bit easier.
But I think in the same breath, Darren, it's important that we, as the professionals delivering it, see ourselves as important enough to be rewarded, not just monetarily. And that's why part of what this has offered to me is the headspace piece and the freedoms that come with it.
Exactly. I mean, the key is, we've all been trained extensively. We spend a lot of time at school, a lot of time at college, on our professional practice courses and picking up experience. The last thing that we as legal professionals want to be doing is non-core legal work, stuff that we weren't trained on, like, introducing new software, phone systems, IT, you name it on the administrative list. We want to be cracking on with the core legal work. And this is really what this program is designed to do, is to allow legal professionals the ability to crack on and do legal work and get paid for it and get paid well.
But also, and absolutely, they have proven themselves to be, but I have a note of my own kind of description that I offer prospects when I'm chatting to them about choice. And, it's in where and how I want to deliver the service. So I chose to close my office building and divest myself of it. So no more rates and no more maintenance and no more admin of just that entity. Kids had grown, moved away, good broadband at home, good facilities at home. I was paying the bills and heating it. So I have a choice where and how I want to deliver the service. My choice whether I want to continue to have a PA or not, because there are structures within the program that can assist with that. I've chosen to hold my PA because it works for me, and clients have this not unbroken, if you like, sense of continuity. Choice is the volume of work I want to do and the days on which I want to do it. I agreed with myself that I would do the client-based work for 4 days a week, and the 5th day was for me. And that might be you're a better sportsman than I am, but hill walking or hobbies, or simply getting out and away. Or it can be other stuff I want to do. And there are other business interests I have, which I'm working on and getting a lot of fulfillment from. So the choice piece has been great.
Brilliant, brilliant. And look, maybe for the benefit of people listening, when you arrived at the decision to make the jump to the independent consultant solicitor program, what for you as a sole practitioner, with the practical implications, what did you have to think about, and what did you have to do, just in basic terms?
Okay, well, again, you and I have worked together to develop what we're calling now, I suppose, an end-to-end solution, and it was a learning curve. I was the first in, and I suppose in some ways fortunate that I had a background in systemization, I suppose, self-taught. So closing a firm is the first piece if you're a solo or a winding down situation. Closing the firm, and that comes with probably a fear and a nervousness, how to do it, what's involved, how do you protect yourself, what's the cost, and Gibson's legally and regulatory wise and cost wise, it can't be and doesn't want to be ever a succeeding firm within the meaning of the regulations around run-off fund and closing. So had to work to that. My identity as Neil Butler and Co. solicitors had to cease. And there was a whole pathway to walk on that in terms of the file reviews and the gathering of accounts and all of that. There are steps. We have well-defined pathway now. I've developed it within my function as lead on the ICS program. So I like to think we walk the path with those who are interested. Winding down the firm involves getting involved with the Law Society. Small practice section of Law Society are very supportive, understanding. The run-off fund is the key piece at the minute. And I suppose it's fair to say that they had some questions at the outset just to understand it. But I know that you and I both had a deep involvement and engagement with them and with their solicitors to look at this. And it has stood the test and stood up to scrutiny. So it's certainly not an excuse for anything less than the highest professional standard platform. I think that's fair to say, would you?
Absolutely. I mean, as you correctly point out, we had one or two challenges joining the dots, basically, for the run-off fund and the other professional indemnity insurance providers on one or two of the transitions. But having come through that and having got everybody, excuse me, comfortable, it's, as you suggest, it's really stood up. The run-off fund appeared to be comfortable. The professional indemnity insurer providers all seem to be a lot more comfortable, and it's moving much more fluidly now. So I think that it was certainly worthwhile going through those few experiences, because it leaves it a lot smoother for anybody that we bring on board in the future.
It is, and I think we've learned the language that's important in terms of explaining it to them. We've learned the language that's important in terms of managing brand identity of the closing firm and the new operation as an independent. There are costs involved. I'm not going to be so silly as to say there are no costs involved, but the costs were administrative for Neil J. Butler and Co. to wind down. So, it was closing out the various supplier accounts. But I mean, the pleasure of having no server on premises anymore, no phone system that I need to be worried about, no IT contracts of those nature. That's just one particular example of the thinning of administrative burden. Then there's the whole thing about contacting client. And I know I would have done maybe 600 plus letters in addition to emails, and we had to do follow-ups. They need to know and they need to be comforted. And no matter that you write to them and say, look, I'm delighted to explain I'm doing something, same service but a different modality, they still got the wrong end of the stick in some respects. And, you know, there's nervousness out there when there's change. But again, with supports in Gibson's on the marketing side and my own experience now, I think we can mitigate those for anyone who's coming on board. So there are stressors, but I think we've identified most of the concerns. We've also identified resolution to those. And I think if you work with us and allow us to help you end to end, it's a far easier journey than maybe the one I took, because we were learning as we were doing.
And tell us this, Neil, again, maybe for the benefit of the guys listening to the webinar, having gone through that and getting to the other side, and your own experience now and dealing with the other solicitors who have come on board, can you describe maybe or explain how it actually feels post, you know, when you've got on board and things are up and running and spinning and so on and so forth?
Well, you'll forgive me as a former solo, focusing on that experience or that existence. How many of our listeners are solos or small firms who sweat October and November? I have enjoyed my Novembers for the past 2.5 years because I don't have the PI cover. That issue is removed. I'm more competitively insured under the Gibson umbrella because Gibsons have a range of sectors, legal sectors in which they're active. So therefore, their price, indemnity-wise, is more keenly priced than I would have been able to get as primarily a conveyancing and probate lawyer. So that's one huge relief. And I know from all the others that have come on board, they would echo that comment. So that's really a gift coming into Christmas without that awful experience. Financial controls and planning, yeah, I was always reasonably good, but that's thanks to my PA, I have to say. But they're keen here in Gibson's, as they have to be for any properly run business. The case and file management structure, you know, it's there. I don't have to think about how it's operating or, you know, are there uplifts to it? Well, it's dealt with. The marketing department, I never had that. So we all kind of know that we should be on LinkedIn and that kind of thing. If you're trying to grow a market share, if you choose to do that, now we have a go-to professional that knows and understands it. I don't have to learn and continue to make mistakes as I learn. So they're all huge pluses, and they don't come at an extra cost. They're built in terms of the fee share structures that are aligned. There are add-on modules that are also available, which you can choose to use. For instance, I'm paying my own PA here. If I didn't, I can go for a Gibson offered module of support from within the firm. So the flexibility is great. And I think in terms of, that's the professional side of it. There are our personal ones. I've mentioned them in passing. That 5th day is very important to me now because I have other interests business-wise, but also personal and life-engaging ones. You know, family are at stages where eldest girl just bought a house with her fiance. They're getting married next year. All of that would mean traveling, that kind of thing. So it's excellent. Working within the larger entity, I suppose, is an adjustment. And I say that deliberately because there are pros and cons. Having been an independent, I'm not asked in this program to relinquish that independence, but I am asked to agree to work within certain systems for the benefit of the practice, the client, and the colleagues within the business. And that's as it should be. If I'm honest, I would have imposed those on myself in my former business. because you have to work within, say, a case management practice. You have to work to law society practices and guides, but there's different ways of delivering those. The independence has not been taken, though, even though you're doing that. And yet you have the benefit of a community within Gibson's. And I'd like to come back to that maybe as far as the other ICS is concerned. What I'm referring to now is the community of, if we're 4 or 5 ICS people, there are 55 core people in Gibson's. I now have access to all sorts of knowledge that I didn't have before. The ICS community that we're building has a different dynamic, but it has a very self-supportive and cooperative community as well. That's something maybe I wouldn't have thought about when I was making my decision, because I was driven by getting rid of burdens, but it has been a positive experience. And I think, would it be fair to say that Gibson's have benefited from the 4 or 5 ICS people and their experience contributing into the Gibson way of doing things?
Absolutely. I mean, it's been hugely enriching to have that level of experience onboarded, and with each new solicitor, each new independent consultant solicitor, it just makes the environment that little bit richer, and the experience that little bit more positive. Particularly given the fact that we have tried to identify people who will add to the team in terms of personality, as you say, in terms of cultural fit, in terms of expertise. But just perhaps on that, the fact that you're now kind of leading out on the ICS side, in terms of kind of profile, what ultimately would you say would be a good fit for the ICS model?
I think, dare I say, age is not particularly important, although experience obviously helps, and you need a certain judgment set which is formed by experience. Not just judgment on the legal file, legal issue, but it's judgment in terms of people engagement, understanding the place systems and risk management has. Sometimes that doesn't come too easily to maybe a newly qualified person. It could be somebody moving from another career into law. So that's the first thing. I think some years of experience and of responsibility would be key. Open-mindedness, I think, Darren, because placing this as a purely commercial prospect or a commercially driven project isn't quite fair to it. I think there's more to it. Open-mindedness in terms of wanting to be constructive in your approach to it, but to embrace what it has to offer. And yet, I'm sure you'll agree with me, we're not perfect. This system isn't perfect. It's evolving every time we have a new experience or a new challenge. So we want to take what other people perceive, get that feedback, help improve the product, for want of a phrase, but also the experience for the participant. If we improve the experience for the participant, I defy you to tell me we don't improve the experience for the client, because we're happier and we're doing better. So I think open-mindedness, I think a range of experience in terms of years, property, probate, elements of litigation have been where we've found it easiest maybe to get people who are interested. We are talking with somebody who has a med-neg interest, but there isn't any bar really to the areas of interest. I think that's reasonable to say. So we're as open-minded, I think, as we want to espouse you should be, if that's fair.
Absolutely. I mean, there's no limit to the areas that we can actually cover. The environment is available, and the solicitor brings the expertise, and ultimately we can deliver it through a very effective platform. That's what we're looking to achieve. Look, I'm conscious of the time here as well, and we want to leave some room for questions. But if you were to summarize very, very quickly, Neil, in your view, the key advantages of the ICS program or the independent consultant solicitor model, what would they be?
Personal choice. I would say relief from a lot of stress and strain. Comfort in the knowledge that as happened to me earlier in the year. I had some small surgery to do, and the pieces were picked up insofar as I needed pieces picked up by colleagues who put their hands up. Simple. The other ICS people said, yeah, we're there for you. And I know that happened with one of the others as well. So those things are not available as a solo. They are now. So choice, support, community, and certainly much reduced stress, and yet I can continue to serve clients to the best of my ability.
Fantastic. Fantastic. Thanks very much. We appreciate that. Justin, you want to jump on?
Yeah, I might just jump in there with a few questions that are coming in. I think some of them are around the business model and how that works. So can you give an example of, say, someone buying a piece of new business and buying a property? How does this work? And is the consultant paid on a percentage of fees brought, or how are cross referrals dealt with?
Sure.
So they're kind of like, how does it work from joining the platform? And do you want to discuss that a little bit?
Yeah, sure. I mean, I'm happy to answer that. Neil, do you want to take it?
I can. I mean, one of the nice things about it is that the AML pain in the proverbial that we all experience is to a great extent lifted by the Gibson dedicated client care team. So if John Smith client is buying a property and he rings me and says, so-and-so referred me, or you did this for me last year, would you do this one for me? I'd be glad to do it. So the point of engagement is me, or they can ask for me, but the AML and the ID and the file setup, the terms, the section 150, that kind of element is dealt with by a dedicated team. So the client is engaged online or personally as they wish. Some of older clients, I would have a need to go and meet them, but the client care team will give me the terms letter, will give me the section 150, and I'll walk the client through on a one-to-one. So all of that is easy. In terms of the end of the transaction, I work the transaction through the Gibson case management system. I have all the supports I need there. We do the bank reconciliations with the Gibson finance team, all of that. The monies are transferred, colleague office to colleague office, and I close the sale. I go off and register and do what I have to do. On the fee, I levy the fee to the client based on the section 150, plus any add-ons, the normal thing. They pay into Gibson's client account because they are Gibson's client. They're not mine. My firm is closed. I then have a fee share agreement with Gibson's, and there's a reconciliation done every month, which I can double check, but it's provided in a very clear to understand format. And the agreed fee is noted from the client account balance is noted, the outlays are dealt with, the disbursements are dealt with, then there's the net, and Gibson's have what they agreed to take, and I have what I agreed to take. And Gibson's pay me to my office operations account. I've no longer a client account, which is one of the burdens I mentioned as being gone. I have an office operations account. I'm a consultant solicitor contracted to Gibson's. So they pay me from the client account fee, which is lifted through to Gibson's, who then share. VAT is, I see Walter Hegarty popping up there. VAT is dealt with in the appropriate fashion. The VAT is collected into the Gibson client account. It's returned on the Gibson side because they're a Gibson client. I am a consultant and I levy VAT on my fee, which is paid.
And just on that VAT one, the one above that, which is, does the ICS pay the insurance, CPD course fees and practicing cert fee for the solicitor?
Go ahead, Neil. Or,
okay. I pay my own practicing certificate. I am a self-employed consultant solicitor on contract with Gibson's, and I pay my practicing cert. They provide the indemnity insurance. My CPD is my obligation. Gibson's will provide some internally because we do. And in fact, I hope to do some stuff internally and offer some of my skill sets to Gibson's as part of their CPD cycle for their staff. I will do my own CPD beyond that. So that doesn't change. But there are synergies to be had if there's worthwhile going, and I know of something, I'll say it to lads and Gibson's, and yeah, there might be a contribution made to me. So it's back and forth.
And just while we have you there, Neil, there's a query there of when one sees the term off counsel in some firms, headed out paper, what does that mean?
Well, the off counsel is a particular, that's the senior counsel designation that has recently, if you like, opened up, and one can apply, and if you meet the parameters, you're allowed, or you're conferred with a designation, shall we say. Richard Hammond, his colleague, comes to mind. Bill Hoolan, those are SC's senior counsel, and they're entitled to describe themselves, as I understand it, as being of counsel. That's not what I am.
So guys, we're kind of in the last sort of 30 seconds to 60 seconds of today's session. Very informative. If there's any final questions, we'll take it. But if you have any final words from your Neil and Darian, that would be great. And Roxy, if you just want to just pitch in and maybe introduce yourself.
Sure, Justin, thank you very much. As we heard today, Darren and Neil really filled in. I think this is a fantastic model from a marketing perspective. We're extremely excited on what we have in the pipeline in the coming weeks, months, and particularly on that, we have an upcoming webinar in the coming weeks. So that's May the 24th. Darren, I just want to make sure we got that date right, so it's on the next slide. May, yeah, that's it. So 24th of May, 1 p.m. You're going to be joined with Darren, Neil, and the other ICS members as well, conducted within internally, a little bit more in depth of some of these questions that we're going to touch base. So that's from me. Thank you.
Great.
Thanks, Roxy. Neil, anything your side?
No. Again, open to dealing with people on a one-to-one too. No obligation whatsoever. Just I'm passionate about it, so happy to talk. Reach out to me directly or through Gibson's, as you will.
Yeah, look, really appreciate the input, Neil, Roxy, and thanks again, Justin, and everybody else for taking the time out to have a listen. As Roxy suggested there, we're having a deeper dive into the independent consultant solicitor model on the 24th of May. Next at 1 o'clock, last for around 40 minutes, but we'll be getting into some of the kind of key components that may help you understand it a little bit better. If it's a thing that you're not really interested in joining the webinar, we're free to talk at any stage. More than happy to jump on a call, a Teams call or a telephone call, and get into it in a little bit more detail. But to conclude, it's a real opportunity. You know, there's a lot of colleagues out there, friends, you know, you hear them say, look, we're stressed out, we're doing this, we're doing that. And, you know, the things that they describe that are stressing them out are not core legal pieces. There is no need to do that anymore. There is an alternative, and we'll happily discuss that alternative with you. There's a better way, and we certainly can achieve that together. So listen, thanks very much, everyone. And Justin, thanks again for inviting us on.
Yeah, guys, we're out of time, unfortunately. So thanks for joining us, Neil, Roxy, and Darian. Our next session is on 3rd of May with David Rowe, buying, selling, and merging. On the 17th of May, we're looking at the overview of solicitor accounts amendment regulations with Seamus McGrath. And on the 7th of June, we're going to be talking about the benefits to running a small practice. So thanks to everyone for joining us today. We'll send out a recording later in the week, actually, and with any of the contact details provided. So, guys, thanks again. Slán.
Thanks a lot.
Thanks, Gurmagan.